is not intended to constitute individual advice. It is recommended that you seek competent professional advice before taking any action.
Good morning, everyone. So this is probably one of the best known tax relief as it applies to so many different people, private residence relief. Now, it provides relief from capital gains tax and the sale of property, also potentially surrounding gardens and grounds, which is or has been their only or main residence at some point during the period of ownership. Now, before you look at private residence relief, you need to first calculate the chargeable gain on the sale of property, take into account any sale proceeds or allowable expenditure. Now, the relief has the capability of reducing chargeable gain potentially to nil, so no capital gains tax will be payable. But private residence relief will only not cover all of the gain where the taxpayer has actually been absent from the property during the period of ownership. And this, this could therefore affect private resident relief available. And we're going to look at what it means for occupation later. Now, where part of the dwelling is used exclusively for the purpose of business, further consideration needs to be made as any chargeable gain on disposal may need to be apportioned to only take into part the non-business part, and we would therefore may restrict private residence relief. I won't be talking today about home offices or building a separate home office in the garden, but get in contact with me after this recording if you want to have a chat about this. Now, you're probably wondering, what is a dwelling house? Well, it needs to be a residence capable of being used as a dwelling, and it must also be used as so. Mere ownership is not enough, and as I said previously, residence is required. And Laura will be taking you through some case law later on what is actually meant by residence. Now, it doesn't have to just be the main building. It can include garage and outhouses, and it can also include surrounding gardens and grounds, which might include greenhouses and sheds if they're within the permitted area. But this will be dependent on the factual background, and review of the legislation will be required to make a definitive decision on this point. Just to show you how wide-ranging the relief actually is, even a caravan has previously qualified as a dwelling home, as has a houseboat. Now, so therefore, for caravans, where the land can be regarded as gardens or grounds of the caravan, that actually might be eligible for private residence relief. However, it's previously been held that where a caravan was not connected to utilities such as like electricity or water, private residence relief was not available. So this will be dependent on the factual background. As stated previously, private residence relief is available for the property and surrounding grounds provided it's not larger than the permitted area, which is currently 0.5 hectares. However, a greater area of land can be exempt if, in review of the size and character of the house, a larger area is required for the reasonable enjoyment of the land of the house as a residence. And as you can see in the bottom of the slides there, Phillips versus HMRC, this is where the first tier tribunal actually gave private residence relief on a piece of land that was 0.5 hectares under this exemption. And they kind of stressed the importance that you need to have regard to the size and character of the dwelling and its context, particularly the location of it as well. And include sort of a little diagram there just to demonstrate with the house and the shed within the permitted area. So you're probably wondering, well, what disposals will and won't qualify for private residence relief? Well, private residence relief can also be attained when having an interest in land used as their residence. And HMRC have stated in the guidance this is going to include a legal or equitable interest. And so what sort of disposals will qualify for private residence relief? Well, you would have sort of a normal property sale, say a disposal of freehold property, freehold interest in a property. It could also potentially extend to gains accruing to trustees of a trust on the disposal of a dwelling house, which is or has been the main or the only or main residence of the person to occupy it under the terms of the trust. Also potentially the receipt of compensation for the destruction of the residence may also qualify, as may compensation derived from the cause of action in respect of the dwelling house. The capital payment for release of restricted covenant might also qualify for private residence relief, because although the covenant relates to a neighbouring land, is held by the individual as a result of their ownership of the residence, and so it does derive from the interest in that residence itself. Now, relief won't be available where the subject matter of the disposal itself isn't actually an interest in the residents. So, for example, we've included some on the slide there, and it could include disposal of shares in the company that owns a residence, disposal of right to unascertainable future consideration for disposal of residence, or the receipt of a forfeited deposit. So in order to calculate the chargeable gain, what you need to do is that you would take the chargeable gain that you calculated, as discussed earlier, and what you need to do, you need to multiply that by the period of occupation of the property over the period of ownership. Now, it's recently been ruled in the Court of Appeal that the period of ownership needs to be calculated as at the date of completion and not when the contracts are exchanged. So next, I want to talk about occupation. And when we mean occupation, we mean looking at both actual and deemed occupation. Now, deemed occupation is where the taxpayer, they're physically absent from the property, but for the purposes of calculating private residence relief, we treat them as living there when we're doing the calculation. Now, the last 9 months will always be treated as deemed occupation on the basis that they have occupied the property as their only or main residence during the period of ownership. Now, when certain conditions are met, this can potentially be extended 36 months for disabled people and those who are long-term residents in care homes. I won't go through the conditions today, so you should get tax advice on these conditions if you wish to claim them. Now, to go through sort of the periods of deemed occupation, in order for you to claim deemed occupation, both before and after this period of deemed occupation that I'm just going to discuss shortly, there needs to be physical occupation. So it needs to be both before and after their only or main residence. Now, where these conditions for deemed occupation are met, it doesn't treat the dwelling house as if it was their only or main residence. So let's say if an individual has another residence during this period of absence, a nomination may be required in order to qualify the property they are absent from as their main residence for private resident relief purposes. And Laura is going to discuss shortly about how to make these elections. Now, there's three main ones. Firstly, any periods of absence for any reason totaling up to 3 years. These periods can be disregarded, whatever the reason for the absence from the property. They could be taking a sabbatical from work and they could be traveling the world. So it's for any reason. Second one is whether taxpayers abroad by reason of their employment or the individual spouse or civil partner's employment. And this period is unlimited. And so this is where the individual worked in employment with all their duties performed outside the UK. So extreme care does need to be taken to ensure that no duties are performed in the UK as to not affect the private resident relief position. This doesn't really cover those who go abroad to undertake a trade or profession or voluntary workers. It's normally strictly to do with employees, so they may need to rely on different reliefs for the absence. And the third period of deemed occupation would be any period where they've been absent due to working elsewhere up to 4 years by any condition imposed by their employer or any similar condition imposed by their spouse or civil partner's employer. And this can be either an employee or a self-employed individual. And just to reinstate the point, so if the case of absence due to employment, the relief also does apply if the absence is due to the employment of the individual's spouse or civil partner and they are living with them. But I won't go through the conditions there, so you should get tax advice on this point. It should also be noted that deemed occupation might also be available where you are not able to reoccupy the property because of the terms of your employment requiring you to work elsewhere. So you still might be able to rely on this deemed occupation. We'll go through examples shortly. As also states on the slide as well, some of these periods can be added together. So, it could be very beneficial for the individuals themselves. So I'll just go through the first example. So say we have Sally here. She bought a house in August 2005. Then in August 2009, her employment required her to go work in Africa. But between 2005 and 2009, the property was used as her main residence. So Sally goes away. She goes to live with her brother in Africa. Upon returning, she was there for 3 years, and upon returning, she came back to the property to live in it as her main residence until the property was sold in 2022. Now, during this 3-year period while she was abroad, she'll be entitled to have it as deemed occupation due to the work abroad exemption, because she had physical occupation as her only main residence before and after this period of deemed occupation. And in addition to this as well, she will always get the 9 months because she has lived in the property during the period of ownership as the only or main residence. Second example, we have Sally here. She bought a house in Leeds in June 2010, and she occupied it as only a main residence until July 2011. Now, her employer then required to go work in Edinburgh and provided her with a house while she was there until October 2014. And she was then transferred to Aberdeen on a long-term contract. She then occupied a house provided by her employer until May 2020, where she sold the house in Leeds to buy a property in Aberdeen. Now, I've put the following periods up just to demonstrate them. So from July 2010 to July 2011, because she lived in the property in Leeds during this time frame, she will get private resident relief as this was her only or main residence. Now, the next period is where people might not be aware of, and it involves the terms of the employment discussed previously. Because she didn't come back to the property in Leeds, there's an issue that she wouldn't get deemed occupation. But because the terms of her employment required her to work in Aberdeen, she'll be able to get relief for this period due to the terms of her employment. But this can only be up to a maximum of 4 years for working elsewhere. So this relief won't cover this additional period here. And the main reason for this is that the provision that we're talking about with the terms of employment doesn't cover where you're 3 years away for any reason. So that's the reason why this period here can't be used. Now, if she was to go back to Leeds after this period here, potentially there might be private residence relief, but in this circumstance, she hasn't. So this is what we're dealing with now. And at the bottom of the slide there, she'll always get the final 9 months exemption. So just to briefly break it down for this period again, this was due to the terms of her employment, and so she would get the maximum of 4 years. But this provision that allows for the terms of employment does not apply to 3 years for any other for any reason. And so to briefly touch on this another period of deemed occupation, a dwelling house will be treated as occupied during the period of ownership if they reside in living accommodation, which is job related, and they intend in due course to occupy the dwelling house as the only and main residence. I won't go through the list of job related accommodation and the other conditions to meet today. I have included the statute references on the slide there if you want to go away and look in your spare time. Now, the last period I want to talk about is there could be issues where the house isn't ready to move in yet and they're carrying out renovations. And, the issue here is potentially that this period would not qualify for private residence relief because, they're not physically there. However, relief will be available from the beginning of the period of ownership, where in the first 24 months of the period of ownership, the individual moves into the dwelling house following the completion of either the construction, renovation, redecoration, or the alteration of a dwelling house, or part of, or the disposal of a previous property that was the only or main residence. So the effect of this really is that the dwelling house will be treated as being the only or main residence from the beginning of the period of ownership until the moving in time. And that's me. Thank you.
Okay, so I'm going to talk about private residence relief elections. So a private residence relief election might be relevant if you own more than one private residence, and importantly, you use both of these residences both these properties actually as a residence, and I'm going to talk more about that later. So in this circumstance, you can make an election to HMRC to nominate one of your residences as your main residence for private residence relief purposes. And the effect of the election is that private residence relief will be available on the disposal of the elected property, thereby reducing or eliminating any capital gains tax payable. The election must be made within 2 years of the date that you have a particular combination of residences, and it's important to know that it's the date that you start to use the additional property as a residence, which would be relevant here. That's important if the date you start to use the property as a residence is different from the date of purchase. I'm just going to, I think we just need to go to the next slide, please. Thank you, Laura. So if you do make an election for a property to be your main residence for private residence relief purposes, your actual occupation of the property would need to meet the conditions for the property to be a residence under TCGA 1992, so that's the legislative reference. So from the case law, that relates to the intentions when it's purchased, utility bills, so are they in the name of the individual or the address of the occupier? Furniture and appliances, are they in there? The degree of permanence and the quality of occupation, so not just the time spent in that property, but the quality as well of that. So I've noted a case down in the bottom corner there, that was Hart and Anor in 2012, and in that case, which was taken to the first tier tribunal, and a private residence relief election was made on a second property, and that was challenged by HMRC. The appeal was dismissed because the occupation of the elected property by the taxpayers didn't meet the conditions to qualify as a residence. And in this case, the property was inherited, the taxpayers never moved any of their possessions into the property, bills were never personally addressed to them there, and they never entertained any guests there. So that just gives you an idea of the importance of it being a residence. However, HMRC's guidance, and I put the manual on this slide, does state that when nominating which residence is to be treated as the main residence, an individual is not obliged to nominate the residence which is factually his or her main residence. So the important point is that it is a residence under the legislation. So if the 2-year deadline is missed, you will no longer be able to elect a property as your main residence for private residence relief purposes, and then your main residence would be determined as a matter of fact, based on what I discussed in the last slide, and looking at all of the relevant properties that you own. It's also useful to know that an election can be varied by a further notice at any time, and it can be backdated from up to 2 years from the date that it's given. And as noted by Ben earlier, if there is a period of deemed occupation for private residence relief purposes, so I know that's what we were discussing earlier, an election may still be required in order to qualify the property that the individual is absent from as the main residence for private residence relief. So under the absence periods deemed occupation rules, the property is treated as a residence, but not the only or main residence. So you'd need to look at where else they were living, and what the nature of that residence is, whether they own a property, whether they rent a property, whether they're living somewhere under a license. That's an important consideration as well. So I'm now going to discuss the concept of private residence relief elections, where an individual may own one property and rent another property. So I think this is a point that taxpayers may not be as aware of, and this point is that a rented property can class as a residence for the purposes of private residence relief, because if you have any interest in a property, which includes any legal or equitable interest, so that ranges from being the owner of a freehold to signing up to a minimal tenancy agreement, the property falls within the definition of a residence. So that could be relevant, for example, if you rent a property near to where you work and you live there during the week, and you own a property in a different location where you live during the weekends and the holidays. So a private residence relief election could therefore be necessary even if you only own one property, because the rented property might be your main residence based on the facts. So without an election, the sale of the property that you own may not attract private residence relief, and you could end up with a capital gains tax liability. So as discussed previously, private residence relief elections should normally be made within 2 years of having a combination of new residences. However, if all but one of your properties has a negligible market value, for example, if one was rented, then a late private residence relief election may be possible. And so that's just a really important point to be aware of. I'm just going to briefly, and also in relation to that one as well, it should be noted that living in a property under a license, for example, in a hotel or lodgings or with family or friends, would mean that you wouldn't have a legal or equitable interest, so the property shouldn't class as a residence for private residence relief. I'm just going to briefly now touch on marriage and separation. Firstly, a married couple who are living together can only have one qualifying property for private residence relief purposes between them. If at the date of marriage they each own a residence, and they can jointly nominate which one of these should be treated as their main residence for private residence relief purposes, and the deadline for the election is 2 years from the date of the marriage or registration as civil partners. As transfer between spouses or civil partners who are living together for any part of the tax year is no gain, no loss. And from the 6th of April 2020, if any property or share of any property is transferred between spouses or civil partners who are living together, the period of ownership of the transferee is treated as beginning at the start of the period of the transferor's ownership. And so that means that they acquire their entire private residence relief history. And this was introduced quite recently, and that's really could have a big impact on people. And before 6th of April 2020, that was only the case if the property was the couple's main residence at the date of transfer. So if in the case of a separating couple, if one of the spouses or civil partners leaves the marital home and their share is disposed of within 9 months of vacating, they should be able to get private residence relief on the period between moving out and the disposal under the normal 9 months exemption at the end of their ownership, because they have lived in the property as their main residence at that point in the period of ownership. There's also, I've got another slide coming up, so there's another extended private residence relief which may be available in this circumstance, and this is where the couple separate and one partner ceases to occupy the property, and his or her share of the property is subsequently transferred to the former spouse or civil partner as part of the financial settlement. Then private residence relief may be available in the whole period between moving out and disposal, even if that's more than the 9 months. But in order for that to be applicable, the former partner must continue to use the property as their only or main residence, and the disposing partner must not make a private residence election for another property in the relevant period. And then just a quick note about non-UK residents, because there are specific rules in relation to non-UK tax residents and private residence relief and the availability of this, and whether a dwelling house can be treated as a residence. But these are subject to the job-related accommodation rules and absence reliefs that we discussed earlier. So that's just something to be aware of, but we won't be able to go into that in great detail today.
And I just want to just quickly mention something as well. I know that we were talking about calculating the period of ownership earlier on today. So just to reiterate what I said was that it has recently been ruled in the Court of Appeal that the period of ownership needs to be referenced on the day of completion, not when the contracts are exchanged. And the legislation doesn't really say what is the period of ownership, but it does include a reference stating what isn't. And it does say in the legislation, it does include any period before 31st of March 1982. And as Laura has pointed out as well, there are some points as well regarding non-UK tax residents. So I haven't talked about the, I won't go into detail regarding the period of ownership for non-UK residents, but further tax advice should be sought on that point as well, because there are some specialist rules.
So thank you very much for attending our webinar today. If you do have any questions, you want to get in touch with us about any of the points raised or anything we haven't touched upon, please give us a call. Our number's on the screen there. And there's also lots of details on our website about how you can get in touch with us. So thank you very much for watching our webinar, and we hope to speak to you soon.
Take care.